The times we go through has refocused attention to the importance of maintaining good mental health and managing stress and anxiety properly. In India, apart from the age old stigma attached to seeking mental health, another issue is being able to afford good mental health care. Private mental health care professionals, much like any others, would be out of the reach of people who are not well off. Mental health care legislation in India was found to be lacking in various respects and had to be brought in conformity with the Convention of United Nations Rights of Persons with Disability and its optional protocol, which India signed and ultimately ratified on the 1st of October in 2007. The Mental Health Care Bill was introduced in the Rajya Sabha in 2013 and eventually passed in 2017. The Act came into force in 2018 and is widely seen as a positive development in ensuring the proper and dignified treatment of persons who have a mental illness. Hey everybody, welcome to Law Kanya. This video seeks to examine the notable provisions of the Mental Health Care Act and the Rehabilitation Council of India Act and examine the statutory framework prevailing in India pertaining to mental health care. So let's begin the video. The Mental Health Care Act of 2017. It was passed on 7 April 2017 and came into force on 7th July 2018. The purpose of the Act is to provide mental health care and services for the persons with mental illness and to protect, promote and fulfill the rights of such persons during delivery of mental health care services and for which matters connected therewith or incidental thereto. Section 2 is definition clause and defines mental health establishment, mental illness, clinical psychologist, etc. Some of the important definitions I have discussed in this video. The first is the mental health establishment. It means any health establishment including Ayurveda, yoga, naturopathy, Unani, Siddha, homeopathy establishment, by whatever name called, either wholly or partly, meant for the care of persons with mental illness, established, owned, controlled, or maintained by the appropriate government, local authority, trust, whether private or public, corporation, cooperative society, organization, or any other entity or persons where persons with mental illness are admitted and reside at or kept in for care, treatment, convalescence and rehabilitation, either temporarily or otherwise. And this also includes any general hospital or general nursing home established or maintained by the appropriate government, local authority, trust, or any other person. But remember, this does not include a family residential place where person with mental illness resides with his relatives or friends. The second definition is of mental illness. What is it? It means a substantial disorder of thinking, mood, perception, orientation, or memory that grossly impairs judgment, behavior, capacity to recognize reality or ability to meet the ordinary demands of life. Mental conditions associated with the abuse of alcohol and drugs, but this does not include mental retardation, which is the condition of asserted or incomplete development of mind of person, specifically characterized by subnormality of intelligence. Now, Chapter 5 of the Act specifies the rights of persons with mental illness. Section 18, subclause 1 specifies that every person will have the right to access mental health care and treatment from mental health services, which are run or funded by the appropriate government. This right intends to make available affordable, good quality mental health care services without any discrimination in a manner that is acceptable to the persons of mental health illness and their families and caregivers. The government must make the following services available for people: acute mental health services such as outpatient and inpatient services, halfway homes, sheltered accommodations, supported accommodations, mental health services to support the family of a person with mental illness, or home-based rehabilitation, hospital and community-based rehabilitation establishments and services, child mental health services, and old age mental health services. Section 18, subclause 5 lays down the mandatory duties of the appropriate government with respect to mental health services. The appropriate government will either be the central government or the state government or the government of the union territory, depending on whose jurisdiction a mental health establishment comes under. The duties of the government include integrating health services into the general healthcare services at all levels, ensuring that no person, including children, will be required to travel long distance to avail mental health care, and to make services available in all districts. The government is also expected to reimburse expenses if there are no government services in the district, and provide free services to persons living below the poverty line. Section 20 of the Act intends to protect persons with mental illness from retarding treatment while they are admitted to a mental health establishment, and includes rights such as living in a safe and hygienic environment, having adequate sanitary conditions, wearing their own clothes and not being subject to compulsory shaving of their heads, etc. Section 23 gives a person with mental illness the right to confidentiality of his mental health care, and physical health care, and bars all healthcare professionals providing care or treatment to a person with mental illness from releasing information, unless it comes within the specified exemptions as mentioned. Section 27 provides the rights to a person with mental illness to receive free legal aid and to exercise any of its rights given under the Act. Section 33 establishes the Central Mental Health Authority, and Section 43 specifies the duties of such authority. It says that the authority must supervise all the mental health establishments under the central government and maintain a national list of clinical psychologists, physiatrists, psychiatric social workers, and mental nurses. Based on the information it receives from the state authority, it must also train law enforcement officials and mental health care professionals and meet at least twice a year. Similarly, Section 45 makes it mandatory for the state to create a state mental health authority. Section 55 specifies the function of such state authority. It states that the state authority must register all mental health establishments in the state and develop quality and provision norms for them. It is also expected to supervise all mental health establishments and receive complaints about the deficiencies against them. It must also register clinical psychologists, mental health nurses, and psychiatric social workers and publish a list of such persons. The state authorities, like the central authority, must meet at least 4 times a year. Chapter 10 pertains to mental health establishments, and Section 65 makes the registration with the authority mandatory unless the exemption is granted by the central government. Once the authority specifies minimum standards, all mental health establishments must meet them within 6 months from the date of which they have been specified. Only after the authority is satisfied that the establishment meets the requirement will it issue the certificate of registration. In order to be registered and to continue to be registered, the mental health establishment must fulfill the minimum standards of facilities and the minimum qualifications for persons they are engaging. The authority may categorize mental health establishments and specific different standards and different categories for the mental health establishment. Section 66 specifies the procedure for registration of mental health establishments, and Section 67 provides for the auditing of such mental health establishments every 3 years to ensure they are complying with the minimum standards for registration as a mental health establishment. Section 68 provides the authority with powers to inspect and inquire on the basis of a complaint or suo motu with respect to non-adherence of minimum standards specified under the Act. Now, the appeals against the decision of the authority will lie to the High Court as per Section 69. Section 73 establishes mental health review boards to hear matters relating to persons with mental illness. Offences and penalties have been specified in Chapter 15 of the Act and includes fines and imprisonments also. Now let's talk about the Rehabilitation Council of India Act 1992. Since there is some ambiguity as to the requirement of the registration of mental health professionals in the Mental Health Care Act, we have to examine the provision of Rehabilitation Council of India Act to resolve this ambiguity. The Act of 1992, as amended in 2000, makes registration mandatory for certain categories of rehabilitation professionals in order for them to practice in India. Section 2N defines the term as being follows: audiologist and speech therapist, clinical psychologists, hearing aid and ear mold technicians, rehabilitation engineers and technicians, special teachers for educating handicapped, vocational counselors, employment of officers and placement officers dealing with handicap, multi-purpose rehabilitation therapists, technicians of such other category of professionals as the central government may, in consultation with the council, notify for the time. Such rehabilitation professionals have mandatory get themselves registered with the Rehabilitation Council of India in order to work in an institution or practice in any part of the India. Now, we can look forward to the analysis and conclusion. The prime focus of the legislation is aimed at ensuring that the state recognizes its obligation to try and improve the lives of the persons with mental illness and proper treatment while they are admitted to a mental health establishment. The definition of mental illness itself is wide and would include within its sweep everything from anxiety to more severe ailments like depression, schizophrenia, etc. The authorities under the Act are the central and the state mental health authorities and also mental health review boards. The central and the state medical health authorities are tasked with overseeing mental health establishments and ensuring that they meet minimum standards and to maintain a list of such establishments. The authorities are also given a power to initiate complaints on their own or on the receipt of complaints to non-adherence to the minimum requirements by the mental health establishments. Such establishments must also be audited every 3 years. Thus, it is clear that the focus of the Act is aimed at regulating these mental health establishments. The Delhi government has formed the State Mental Health Authority as required by the Act and specified by the minimum standards for meeting the register requirements. Not all states have constituted a state mental health authority and rules. For instance, Goa is yet to do so. The registration of mental health professionals in the state and making a list of easy, accessible is extremely important and beneficial to any person desirous of availing mental health services, as they can access the list of the professionals in their state. This is a benefit that applies across the board, as even those persons who cannot afford mental health care can see an organized list of recognized mental health establishments. The fact that these establishments have been recognized by the state health authority would give at least some credibility to the mental health professionals as to fulfilling the minimum requirements. Therefore, there should be some background checks of such professionals who are publicly listed. This exercise should be undertaken by all the states in India and to be provided a central mental health authority at the earliest. There is an ambiguity as to whether all categories of health professionals will come under the purview of the Act and have to get themselves registered. The definition of mental health establishment is exclusive. However, the way it is worded does not suggest that individual mental health professionals would not operate out of establishments would be covered under this embed would have to get themselves registers. As per the Rehabilitation Council of India Act, the only kind of psychologists who have to get themselves mandatorily registers to practice are the clinical psychologists. Unlike in other countries such as the United States of America, there is also no need to give a written exam in order to become licensed to practice in India. One possible solution for the central government in the consultation with the council to add all categories of mental health professionals who are practicing or are desirous of practicing in India. Thus, while the Mental Health Act is focused on ensuring that the mental health establishments functions properly, a suitable notification by the central government adding more categories of professionals such as therapists, counseling psychologists to definition of a rehabilitation professionals may be one of the possible solutions to remedy this problem. However, given that the Rehabilitation Council of India is perceived by the persons working in the field as not being inclusive and have good standards of practice, the better solution would be to form a separate body or an association which regulates the registers all categories of mental health professionals and make sure everyone practicing in India is registered. There should also be a written exam to become a licensed or to practice as a mental health professionals or therapist in India. In conclusion, the enactment of the Act is a welcoming step in trying to ensure the maintenance of some minimum standards in the mental health care establishments, keeping them in check and making the same accessible, available to all classes of citizens. However, there is a need either to amend and law and in a way as to include everyone in its ambit and bring the requirements to practice up to the international standards. I wish every one of you a very happy Mental Health Day. Thank you for watching this video. If you liked it, please subscribe to it. Thank you.